Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Mr. Martinez, you may continue.
We were talking about the litany of the defendant's lies, and we were at a point where we were going to talk about the lies to the police officers. And you've heard so much about that that almost there's an effect such as, well, she did it. It's let's accept it and move on. But it is an important factor, not because it is important because she lied, but because of how it fits in to her particular plan. And one of the things that we have to think about when we talk about lies is that, and you think about what she told the police officers, is that maybe there was some exaggeration that was going on with regard to what she told the police officer, or maybe there was some minimization that was going on. In terms of exaggeration, one of the points that needs to be made is that Robert Geffner, who was here yesterday talking to you, and said, well, exaggeration really isn't a lie. Well, it is, because it's not the truth. And so some of the things that the defendant told the police officers, somebody may say, well, no, that's a little bit of an exaggeration, maybe it isn't. But at the time that she spoke to the police officers, it had been some time, it was July 15th of 2008 when she was arrested, it had been over a month since she had killed Mr. Alexander. And during that time, she had had time to think about what was going to happen if she spoke to the police. And so it's important from the aspect of somebody who's thinking about it, somebody who is planning. It shows that this individual had the forethought to have a story ready when the police officer came to her. And this individual is of such strong will that even in the face of what the police officer was talking to her about, she would actually not budge initially when she was spoken to by the police officer. For example, one of the things that she was asked on the first interview, well, isn't it true that you were there? And she kept saying, no, I wasn't even there. How could I have possibly done this if I wasn't even there? And then she was asked, well, isn't it true that your fingerprint or your palm, it was actually a palm print, but the fingerprint, isn't it true that the fingerprint and blood was there? And she said, well, of course it's there. I've been there all this time. And so it shows you the adaptability and how nimble this individual is, such that when she gets in any situation, whether it be involving Mr. Alexander or here in court, this individual is quick thinking and is good on her feet. And so that when she's talking to you on cross-examination and you get those answers are designed to manipulate. And so that's why those statements to the police are important, because they show how she can attempt to manipulate things and is able to say whatever fits the story at the time. So initially, when the police came to her, when Detective Flores came to her and asked her, well, this is what we have, let's talk about it. She denied everything. And she kept saying, let me see the photographs. I want to see the photographs. The reason she wanted to see the photographs is because she wanted to conform her story to what the police knew or what she thought the police knew. And in fact, in other conversations, during the telephone conversations, they discussed it. And that just shows you this type of individual that can adapt, if you will, as she's going along with the interview with the police officer. And in asking to see the photographs, it's interesting that she asks that. And the only reason that I mention it is because previously, when I was showing the photographs of the killing of Mr. Alexander, we had the defendant crying. Well, why did you want to see the photographs when the police officer was there? You knew what had happened, and yet she's still asking to see it. Again, it's just another form of manipulation to have you feel some sympathy for her as she sits there with the red nose, face down, apparently crying. But yet she asks the police officer, can I take a look at these photographs? The police officer, of course, did not show her the photograph. So the first story on July 15th wasn't even there. Wasn't even there. Then has overnight to think about it, and on July 16th, changes it. Changes it to something else, because it'll make much more sense. Because now she knows a little bit about what they have there. She wants to now be able to say that she was there. But what does she do? She says, not just that she was there, but she makes herself the hero. Just switching it up. Not only does she say that she was there, but she makes herself the hero in the sense that she pushes the woman down and has the gun pointed to her head and by luck is not killed. But she's able to push people aside, and then she wraps it up by saying, I wish I could have stayed there. I should have fought more. I did fight, but I should have fought more. And then away I went. Again, trying to paint herself. Not only that she was there, but again, that she was this hero attempting to not only tell a different story, but to manipulate that story to make her look better. Years go by, and then we have the story that we have now. This nonstop litany of lies by the defendant just does not stop. She has lied to various groups of people. She has lied, as we said, to you. She has lied to the medical health care professionals. She's lied to the police. And she's even lied to the media, something that she has craved. This individual here craves the media, loves the media, went on national television to talk about this. And what did she do? Not only did she lie to them, but she made herself seem like such a calm person. I wouldn't do that. Didn't tell any of the things that we see here today. And of course, it's not a confessional when you go there, but it is demonstrative of the fact that she's a chameleon, and she'll adjust to the situation and make up whatever stories are appropriate for her at the time, whether it be the media or somebody else. The same can be said is true about her friends, the people that she has, the friendships that she has. She lies to them, and she does things that almost make you step back and say, what could you possibly gain by that? When, for example, she talks to Leslie Jodi and makes up this thing about her kids and Mr. Alexander's kids playing together. She didn't have to go that far. The point I'm trying to make is that these lies are lies, but then she goes even further with them just to sell them, to manipulate the person into thinking that they are actually true. For example, with Leslie Jodi, she could have just said, oh yeah, I speak to Travis every now and then, but then she adds, oh, but I want our kids to play together. When Dan Freeman called her, well, she didn't have to, after he called her and said, I don't know, what happened, but Travis is dead, she didn't have to then go and talk to the bishop. She does these things because she's such an ornate liar. It just has to add the extras to it to really sell it. And that's what she did for you for all of those times, all of those days that she testified to you. And the reason that I bring that up, this ornate storytelling, is because it applies to her defense and her defense really is based on lies. It really is. And if you can say, for example, she presented it as if it was in self-defense, but not only did she present it as if it were in self-defense, she added some ornate lies to it. For example, one of the things that she added was this physical violence that supposedly Mr. Alexander inflicted upon her. But she doesn't just say that he inflicted these 4 incidents of violence. She goes into great detail about it. For example, she talks about the one in August of 2007 where he goes upstairs and he's banging his head up against the wall, just very flowery, very out there, because then she's again the center of attention. She's being the calm one. She's being the person that is the individual that you would look to for the answers. It's not just the lies. She's a very good liar, but she, on top of that, is a very sophisticated liar in the sense that she adds these extra elements to it. And she did that with regard to the acts of domestic violence. And they are lies. If we are to look at her journals and sit back and take a look at what she writes, those journals tell you that there were no acts of domestic violence. Have you been given any reason whatsoever, other than this law of attraction, and other than another Alice Laviolette, somebody who has trouble with the truth, other than that, vouching for them, do you have any reason to doubt what is being written there? Do you have anything that the defendant has said that has corroborated in terms of the domestic violence? You have the journal entries indicating that they did not happen. You have friends indicating that they never saw it. You don't have any medical reports, any police reports. You don't have anything. And as we get talking about these, there are lies, and then there are monumental, huge lies. And she made this up because that fit her defense. And one of the other things that she did with regard to this is that not only did she make up this lie for her defense, the other thing that she did is that she created a lie that really involves behavior that is a hot button kind of topic. How horrific it is to be accused falsely of being a pedophile. He's not here. He's not here to say, no, that's not true. She can say to Alice Laviolette that it was on the computer, the images, but then Alice Laviolette comes in and says, no, that's not what she told me. But remember, Alice Laviolette has a problem with the truth. And so Snake goes to the computer and doesn't find anything there. Oh, no, I changed my mind. It was actually images that were like this. And how does one defend that when there are no images there? The police looked through the attic. The police looked everywhere. How absolutely hateful that allegation is, and how absolutely extensive she was with it. But remember I said that she went a little too far with these lies? First of all, her journal indicates that there wasn't such an event. Second of all, the text messages also indicate the same thing. And what human being, if that is the allegation, if they really are caring, what human being doesn't go to the police and say, or somebody else, this person is a pedophile? For her, instead what she does is she says, no. And she talks about all these phone calls going back and forth, and that also doesn't match. What she does, well, it's the new approach. It's the new approach to pedophilia. What does she do? Well, let's jump in the sack. That's what we're going to do. At least that's what she tells you now. But with regard to Alice Laviolette, no, she didn't. She can't even keep that together. If that is the truth, and if that is what happened, wouldn't you expect that her journal, if she had it, if she didn't write about it, at least wouldn't have said that nothing noteworthy has happened? She has gone too far, at least with regard to that particular allegation. And at least in this allegation, it is fortunate that the police did have Mr. Alexander's laptop, and there weren't any images of children on it, none whatsoever. They checked throughout the house. There was nothing inside of the house that indicated anything like that. There weren't any photographs. There wasn't anything. And so this allegation of hers, whether it was on the computer or whether it was in photograph form, just went a little bit too far. These lies to take from Mr. Alexander, the only thing that he has left, his reputation, is just a little bit too much to, in light of what we know, in light of what she says, it's just too much even in this particular case. It is a hateful allegation with nothing to support it. But can you imagine what goes through somebody's head when they hear it for the first time? That person does not deserve justice. That person doesn't deserve anything because of what he did. It's so easy for her to make these allegations. It's so easy for her to get on the witness stand, as you've seen, and lie. And this is really the pinnacle. It doesn't get any higher or worse or lower, whatever way you want to look at it, than that. Well, how do you judge that allegation? Well, the judge has. How do you judge these sorts of allegations? Well, just like everything in this case, there are rules. And those rules are the jury instructions, such as the ones that have been read to you today. And one jury instruction particularly deals with this aspect. It's the credibility of witnesses' instruction. I know the judge has read it, but because it's so important, it is worth my referencing it because it directly relates to the two primary allegations in this case, that of physical abuse and the fact that Mr. Alexander was interested in little boys and girls, according to her. It tells you that in deciding the facts of this case, you should consider what testimony to accept and what to reject. What it's telling you there is that you ultimately decide whether or not this person here who is the epitome of a liar, whether this individual, you're going to accept or reject what she tells you. Are you going to pick and choose some things of what she says and then accept some other things? How is it that you can know with any certainty whatsoever whether or not she's telling the truth about anything? It says you may accept everything a witness says, or part of it, or none of it. The state submits to you that you are, based on what you've seen, based on what you've heard, and based on the testimony of others, that you should accept none of it. It doesn't mean that the 18 days that she was on the witness stand are wasted. No. What that means is that you're finally able to see this individual in the light of day. You're able to see how she reacts. You're able to see that when push comes to shove, she'll look each and every one of you in the eye and lie. Doesn't matter where. And this instruction then goes on and says, in evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life. Important matters. What kind of matters would those be? Medical care. Would you, anybody, not you, but anybody, go to a doctor who has lied to them consistently about major aspects of their life? No, people will not go to a doctor who lies to them. And the factors that you are to consider are the witness's ability to see or hear or know things the witness testified to. If we're talking about the defendant, she was there. She knows. The quality of the witness's memory. The quality of her memory is incredible. Absolutely incredible. Down to follicles of hair. Unless it hurts her. Then the fog rolls in. Then there's an excuse. Then there's a reason why she doesn't remember. She has an incredible memory, all right, when it comes to lying. And the witness's manner while testifying, how it was that she testified, how it was that the defendant testified. Well, you saw her at times attempt to cry. You saw her at times get angry. You saw her at other times just sullenly stand there. And you saw her at times when the questions were getting difficult, snap out and try to somehow make the person that was asking the questions the villain, saying, well, you're scrambling my brain. It's not my fault. Again, it's not my fault. It's the fact that you're asking me these questions, just like Travis. That's exactly what's going on here. So that's not my fault that I keep lying here on the witness stand. It's yours. Because of the way you're asking me the questions, the fact that you're raising your voice, that's whose fault it is. And that's why I can snap at you from the witness stand, I can smirk at you from the witness stand, and look knowingly towards the jury, because not her fault. It's the person who's asking the questions. Whether or not the witness had a motive, bias, or prejudice, if there is any witness in this case who had a motive to lie, it's this defendant. She's the person that's charged. All of the other witnesses that came here, some of them had a motive. For example, Alice Laviolette, she had a motive to lie. I mean, maybe perhaps it was her reputation that she was interested in, or things like that. All the other individuals, for example, Ryan Burns, why would he want to lie about anything? He lives in Utah. He just met her at one time. There's no reason to believe that he was going to be making these things up. Amanda Webb, why would she want to come in here after all the work that she's done and make things up? The only person with a motive is the defendant. So when evaluating her testimony, that's something that you need to consider. When it's to her benefit, she's going to lie. whether the witness, the defendant, was contradicted by anything the witness said or wrote before trial. Well, she wrote, for example, in terms of these two allegations involving the pedophilia and involving the domestic violence, that they didn't happen. Additionally, she never told anybody. And the reports out there, if there aren't any reports that would corroborate what she said. So, in terms of the pedophilia, well, she says it was on the computer. Well, the computer doesn't show that. And they even went back and looked, and traced and looked everywhere. The house, there was no implements, if you will, or anything associated with that kind of conduct. And so in this case, nothing supports what the defendant said. And then you're asked to take a look at the reasonableness of her testimony in light of the other evidence. In order for her to prevail in this case, in order for you to believe her, because it actually comes down to whether or not you believe her. If you believe her, then certainly you can apply the jury instructions. But it comes down to whether or not you believe her. The other evidence, all of the other evidence that's out there, contradicts her. So you have to go against all of the evidence that's out there, turn your back on all of that, and say, I believe her, therefore I'm going to find in her favor. The state submits to you that, in light of everything, that's not something that you should do. So what standard do you apply? Well, the standard that you apply is the burden of proof instruction, which tells you proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. Firmly convinced is the term. It's not any of the other terms that you may have heard anywhere else in life. It's just firmly convinced. And it does tell you there are very few things in this world that we know with absolute certainty. So absolute certainty is not required. And it does say that in criminal law that the law does not require proof that overcomes every doubt. That's not what we're talking about here. You just need to be firmly convinced. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. That's how it reads, and that's the procedure that you indicated that you would follow should you be chosen to go back there to resolve this case. Once you make that inquiry, and once you find the defendant guilty, that's the end of the inquiry. The other language that falls after that involves you finding reasonable doubt. But if you find, based on your consideration of the evidence, that you are firmly convinced, that's the end of the inquiry. You don't need to go any further. And there is only one charge in this case. And the charge is first-degree murder. And first-degree murder can be committed in one of two ways. Obviously, you notice that there is not two charges of first-degree murder. There is only one. But there are different ways in which these can be committed. First is premeditated murder, or second is felony murder. With regard to premeditated murder, there are lesser included offenses, as the jury instructions have told you. There are other offenses, not necessarily lesser, but other offenses that are involved. With regard to felony murder, there are no lesser included offenses. So, for example, if you are considering felony murder, there are no other offenses that are to be considered. The only issue with regard to felony murder is whether or not in the course of a felony, she killed him. That's basically what the law says. And if you find that, that's the end of the inquiry. You don't consider lesser included offenses. Premeditated murder does have these lesser offenses. But in terms of the tabulation that takes place at the end, for example, 9 of you could find that this was premeditated murder, 3 of you could find that this was felony murder, and it's still first-degree murder. You do not have to be unanimous as to the theory involving the murder. Or you could be 6 and 6, or it could be 12 for premeditated murder and 12 for felony murder. It's still only one charge. You do not have to be unanimous as to the theory of the crime. And let's talk about premeditated murder. Well, it requires that it be proven that the defendant caused the death of another person. Well, exhibit number 207, he's dead. That element is proven. Well, the defendant intended or knew that she would cause the death of another person. That's also proven. One of the things that we know in this particular case is that, amongst other things, she slit his throat, she stabbed him in the heart, and we also know that she shot him. There are 3 different ways that she killed him. So, did she intend? Sure. Did she know? Absolutely knew. Remember, I was talking about how directed it was to the throat. If you do that, then you know, anybody knows, that if you do that to the neck, you're going to kill somebody. So she both intended it or knew. In other words, it could be either or. In this case, she knew. And also intended it based on what we see in this particular case. So those elements are satisfied in this case. There is no doubt about that those 2 elements are satisfied. Now the issue is whether or not she acted with premeditation. And premeditation means that a defendant intended to kill another human being, and then there's the disjunctive or knew. It doesn't say the defendant intended to kill another human being, and then it stops. It says intended to kill another human being or knew she would kill another human being. That is the element that's above in number 2. She knew that she was going to kill him. There's 3 different ways that she killed him. One of those 3 satisfies this, knew she would cause the death of another person. And after forming that knowledge, after knowing that she was going to kill him, because it talks about intending or knowledge, after knowing, after forming that intent or knowledge, reflected on the decision before killing. And the key here is, what is reflection? What does that mean? And it defines it for you. It tells you that it is this reflection regardless of the length of time in which it occurs. That distinguishes first-degree murder from second-degree murder. What that is telling you is that you don't have to have a month of thinking about it or knowing about it. You don't have to have a week between the thinking and knowing and the killing. You don't even have to have a day between the thinking and the knowing. You just have to have a length of time regardless of the length. So it can be very short. It can be as short as stabbing him in the shower and then, after a couple of minutes, chasing him down and going for the throat. No one can dispute that he walked that way to get away from her. No one can dispute that he was already injured. He was already going to die. When this was applied, by this I mean the strike to the throat, she knew he was already going to die, but that type of injury indicates you want that person to die. Additionally, when she shot him in the head, although he was already dead, that also indicates that she wanted him to die. It does say that while reflection is required for first-degree murder, the time needed for reflection is not necessarily prolonged. Again, it's telling you it doesn't have to be days. It doesn't have to be hours. It doesn't even have to be minutes. And then it tells you in the space and time between the intent or knowledge to kill and the act of killing may be very short. In this case, I guess it depends on who you ask, this was a long period of time for Mr. Alexander to be going through this. Just a long period of time between the stab, wounds to the heart, and the shower when he was defenseless, to the time that he was trying to get away and going along the wall and absolutely falling down. So in this case, it can be very short. She killed him 3 different ways. She knew that she was going to kill him. Additionally, not only that, she brought the implements. She brought the gun. If she didn't bring the gun and it was Mr. Alexander's, then you have a burglary. And that implicates felony murder. Because she came and she took his gun. If what she's saying is that she stole his gun, did she have his permission to take that gun? According to her, it was his gun. If she took his gun, then that's a burglary. And if during the burglary somebody dies, i.e. stealing the gun, then that's premeditated murder. Either way you look at it. But we'll talk about that in a little bit more. And an act is not done with premeditation if it is the instant effect or a sudden quarrel or heat of passion. How do you know if it was or wasn't the instant effect of a sudden quarrel or heat of passion? Well, you can take a look at some of the photographs that we have, and they will tell you that it wasn't the instant effect of a sudden quarrel or heat of passion. 160 tells you, does that guy look like he's ready to fight? That guy looks like he's ready to fight? And who's telling us that this is the instant effect of a sudden quarrel or heat of passion? A liar is somebody who is telling us that. A liar who was dressed at the time. A liar who was poised to strike. If she didn't have a plan, why does she have her clothes on? Why does she need to have her clothes on? And why is it that the gun is with her? She says, oh no, the gun belonged to Mr. Alexander. But if you remember, on June 10th of 2008, she called unsolicited to this police officer and said to him, oh no, Travis never had a gun. Travis never had a gun. The only thing that he had were his fists. So, and you have that on tape. There is no doubt that she said it. In fact, there is a tape that says, Jodi Arias' number is whatever it was, and you heard her voice. And you also heard her saying, he did not have a gun. At that time of the investigation, she didn't know how important it was going to be. She didn't know what lies she was going to be telling in the future. She said he did not have a gun. So if he didn't have a gun, she brought it. And you know that she did bring it. You know about the burglary, supposed burglary of her grandparents' house. And so she says that in order for you to believe that this was a sudden quarrel or heat of passion, you have to say to yourself, well, you know, she called the police on her own and she lied to him, but since she's been such a liar and she lied to us in this courtroom, I'm now going to decide to believe her when she makes up a story and says, oh, his father gave it to her. And in addition to that, I'm going to have to believe that the shooting did not occur in the closet as she told Alice Laviolette, because that's what she told Alice Laviolette, the person who took the stand. Isn't that what she told Alice Laviolette? Do you remember what Alice Laviolette testified? That that's what she told her. And in fact, there was a recording of the conversation between the prosecutor and her at an interview that took place in November of last year, in which you heard her say, oh yeah, she told me that the shooting happened in the closet. You're going to have to disregard all of that so that you can even get to the sudden quarrel or heat of passion. That's the problem for the defendant. Are you going to be willing to do that? Especially when the police have looked in that place and there wasn't anything indicating that there were any bullets there. There's nothing to indicate that he had any cleaning supplies. Nothing to indicate that there was a gun. The other thing that is problematic, that it would allow you to reach that, is the shelves. You would have to, you know the shelves, you've seen what the shelves look like, those shelves that were in the corner, and by her own admission, she stepped on the second shelf as she was going to get the gun. You saw what happens to those shelves when you put a little bit of pressure. They move down this way. And you saw the photographs. There was nothing that was the shoes that were there. There was nothing that looked that there had been any activity there. Everything, the photographs, the forensic evidence, her statement says that there was no sudden quarrel or heat of passion because she brought the gun. You would have to, again, throw aside everything else she has said to find that there was an instant effect, a sudden quarrel or heat of passion in this case. What do you want to do as you sit back and deliberate? What do you want to do with one of the first conversations that she ever has with the police before she knows what the issues are and says, "You didn't have a gun"? What possible reason or justification can she give you to say, at that time, I lied to him? Why? Well, she said before, well, I was afraid initially. She said when she spoke to the officer back on July 15th. That's why I made that first story. Then the second story, well, I was trying to not get in trouble. But those weren't present. Those reasons were not present on June 10th of 2008 when she called this detective unsolicited to talk. It's because she wanted to learn about what the police knew so that she could incorporate it in her story should something come up. But with the truth, you ain't got to remember nothing. And she forgot about some things and made that statement involving the gun. And that's problematic for her. It will stay as part of this record, and it will require you to sit back there and listen to that and say, you know what? She was lying there instead of telling the truth there. And that would require you to disregard the fact that a .25 caliber handgun was taken during a supposed burglary of her grandparents' house, and that was the gun that was used to kill her. The issue of the gun will not go away, especially since she said that he didn't have one, especially since she also indicated that there was a circuitous route through the closet, especially when she could have just walked out. The guy's naked. He's not going to run after her outside naked. And then indicating that she came through the closet, shoots him in the closet, according to some accounts, shoots him outside of the closet in the bathroom, and grabs a gun that she believes is unloaded. If she believes the gun is unloaded, what is she going to do with it? Throw it at him? Why stand there with the gun if you know it's unloaded? None of it. Absolutely none of it is true. You could even be charitable and say it doesn't make sense. I'm not asking you to be charitable. It's an absolute lie of this issue about the gun. She said it, and she is wedded to it. I won't even discuss the lesser included offenses because of the issue involving the gun. She brought it herself. Felony murder requires the state to prove two things. The first one is that the defendant committed or attempted to commit a burglary in the second degree. What is a burglary in the second degree? And notice it says attempted or committed the burglary. The crime of burglary in the second degree requires the defendant, in this case, to enter or remain unlawfully in or on a residential structure. We don't know if she was invited in. We really don't know if she was invited in at all. So, but did she remain unlawfully? I think it's not a stretch to say that an individual who owns a home and is being stabbed to death, that the person that's doing the stabbing there no longer is entitled to remain lawfully in that house. No, I may be charitable, I may be a nice guy, but you know what? If you start stabbing me, you're no longer here lawfully. That consent to come in is no longer there. If you keep stabbing me, that's it. It is not a stretch of the imagination to say that. And we understand, the state understands that Mr. Alexander is not here to say, I revoked my consent. But if he's being stabbed, if he's having his throat slashed, and if he's being shot, it is not a stretch to say, based on circumstantial evidence, to say that she remained unlawfully. So she has remained there unlawfully. Is it a residential structure? It absolutely is. So that's his house. And she did so with the intent to commit any theft. Well, at some point she stole the gun, according to her, or a felony therein. You can bet that stabbing somebody is a felony. So he doesn't want you to be there, and you're stabbing him, and you're killing him. That's a felony. So the elements of burglary have been satisfied. So we go back to the first prong, and it says the defendant committed or attempted to commit burglary in the second degree. Yes, he did accomplish the burglary. So that element is satisfied. Number two, in the course and furtherance of committing this burglary that we know that she committed, or immediate flight from it, in other words, she took off and she took his gun. So that's the theft right there. And as part of that, even if it wasn't her fault, the defendant caused the death of another person. If you are committing...
In this case, the law.
Overruled.
The defendant caused the death of another person. And she did cause the death of Mr. Alexander during this burglary. She took off, and she took off with his gun after stabbing him. So she has committed murder in the first degree under both theories. It isn't just one theory that she has committed this crime under. And so now you're left with the decision that you have to make. The one admonition that I leave you with is that these jury instructions are not advisory. They are mandatory. And it's a situation where you go back there and you read them. And as you sit back and you decide this case and you attempt to reconcile the lies with what actually happened, keep in mind that the defendant has attempted to manipulate you, has attempted to paint the picture for you. For example, something like this. This is what she wants you to believe. Something like that. There's Mr. Alexander and her. That's what she wants you to think. That's what the feeling that she wants you to have. But actually, reality is this. That's really what we're talking about in this case. That's his back, not his throat. But you've seen his throat already. And that's really the reality in this case. And as you consider this case, and as you ponder your decision, one of the things that I want you to consider that is symbolic of this whole case is that this issue involving the gas cans. What she wants you to do, because you know it's a lie, what she wants you to do is disregard it. But symbolically speaking, when she asks you to disregard it, what she wants you to do is she wants you to carry those gas cans for her. She wants you to help her fill them with gas. That's what she wants you to do, symbolically speaking. What the state is asking you to do is to not leave this courtroom filled with the stench of gasoline on your hands. That's what we are asking you to do, because it's not true. But she's already talked to you about these gas cans. It's not true that she returned them, but she's asking you to help her. She's asking you symbolically, help her by carrying them out and taking those cans with you. What the state is asking you to do is your duty. And the judge has indicated that your duty is to follow the law as she's given it to you and apply it to the facts. And in asking that, the state is asking you that you return a verdict of guilty, and that you return a verdict of guilty as to first-degree murder. Not only as premeditated murder, but also as to felony murder. For no other reason than it's your duty and the facts and the law support it. Thank you.
All right, ladies and gentlemen, we were here late last evening, so we are going to adjourn for the evening now. Please be back tomorrow morning. We will start promptly at 9 o'clock. Please remember the admonition. Are there any questions? You are excused. Have a nice evening.